Hello viewers, Attorney Buado here again. Welcome to Criminal Law Jurist. Last episode, we took up the due process clause of the Constitution. Now, our topic is the equal protection of laws. This is Episode 1, Part 2 on the limitations on Congress to enact penal laws. What is equal protection of laws? It is a guarantee that all persons or things similarly situated should be treated alike, both as to rights conferred and responsibilities imposed. The operative phrase here is similarly situated. If there is a difference in the situation of classes of persons or things, then the clause does not apply. Equality of operation of statutes guarantees equality, not identity of rights. The Constitution does not require that things or persons which are different in fact be treated in law as they were the same. The Equal Protection Clause does not forbid discrimination as to things that are different. What are the elements that we should look for so we will know whether the valid classification allows the equal protection of law to not operate? Take note that the equal protection of laws allows classification. It is required that things and persons be classified validly, meaning that the classification is reasonable. Classification is valid if it has four necessary elements. First, the classification should be based on substantial distinction, which makes it really different. That it must be germane to the purpose of the law. That it must not be limited to existing conditions only. And that it must apply equally to each member of the class. So let us give an example of a law that is based on valid classification. Republic Act 9262, the Violence Against Women and Children Act, is based on valid classification. It did not violate the Equal Protection Clause by favoring women over men as victims of violence and abuse to whom the state extends its protection. Because RA 9262 has all the four elements of a valid classification. For example, RA 9262 rests on substantial distinctions, such as the unequal power relationship between women and men, that is also known as gender-based violence. The fact that women are more likely than men to be victims of violence, and the widespread gender bias and prejudice against women all make for real differences, justifying classification under the law. The classification is germane to the purpose of the law. The distinction between men and women addresses violence committed against women and children to protect the family and its members, particularly women and children, from violence and threats to their personal safety and security. Third, the classification is not limited to existing conditions only, and it applies equally to all members. The application of RA 9262 is not limited to existing conditions when it was promulgated, but to future conditions as well, for as long as the safety and security of women and children are threatened by violence and abuse. The law also applies equally to all women and children who suffer violence and abuse. Now, RA 9262 does not single out husband or father as the culprit. As defined, violence against women and children may likewise be committed against a woman with whom the person has or had a sexual or dating relationship. Take note the law used the word person, which is a gender-neutral term. Therefore, it also encompasses women in lesbian relationships. Next, the law does not preclude the application of the principle of conspiracy under the revised penal code. So women can also be violators of the violence against women and children. In one case, the parents-in-law of the victim were held respondents in the case of Gotan versus spouses Tan, upon the allegation that they and their son, Gotan's husband, had community of design and purpose in tormenting the victim by giving her insufficient financial support, harassing and pressuring her to be ejected from the family home, and in repeatedly abusing her verbally, emotionally, mentally, and physically. Chief Justice Puno said that the history of the women's movement against domestic violence shows that one of its most difficult struggles was the fight against the violence of law itself. If we keep in mind that the law will not again be a hindrance to that struggle of women for equality, will be its fulfillment. Accordingly, the constitutionality of RA 9262 is sustained. So what did we learn today? Congress cannot arbitrarily enact laws favoring one class of society or thing as against another, but must comply with the Equal Protection Clause. On the other hand, one class of persons or things can be favored as long as the classification is valid and complies with the 4 requisites for exemption from the application of the clause. Really, criminal law is complex but not boring. So if you want more excitement while studying law, stick around. For the next episode, we'll discuss about cruel and unusual punishment. To give you a foreglimpse of what's ahead, let me ask you, would you rather be jailed in the corner of EDSA and Cubao for 1 week or stay in jail for 6 months for shoplifting goods valued at 20,000 pesos? That would be the topic of the next episode.